Hello, everybody, and welcome back to the final part of day one. It's been an intense 3 panels and a keynote. So we're switching gear. This is a fireside chat. This may be the fire. You're all imaginative. I think you can imagine it. So it's a fireside chat. So the idea is whether or not you can think of this as a fire or not, you're meant to relax, to reflect more broadly. And we're all meant to reflect more broadly about the issues we've been discussing, the topic we've been discussing, the ICJ at 80, but from a slightly different angle. And we're joined for this exercise by Patrick Wintour, who's the diplomatic editor of The Guardian. So Patrick, you're here to help us reflect. I'm sure you'll succeed because you come to this with an exciting perspective and also a perspective that is probably slightly different from that of most of us in the room. You're looking at the International Court of Justice and other courts and international law more generally from the perspective of a political journalist, a diplomatic journalist, who's an expert in foreign policy matters, who is an astute observer of foreign policy issues and the role of international law and international courts, but who has probably a greater sensitivity than most of us for the political discourse surrounding it, perhaps the limits, and perhaps also for the perspective of change, as one of these courts, the ICJ, approaches its 80th birthday. You're also, if I may say so, sometimes the voice of reason in an often hyperbolic discourse on foreign affairs and foreign policy issues in some of the British papers. So we're really happy that you accepted James and my invitation to join us here for this fireside chat, and perhaps without sort of prejudging anything, let's start by welcoming Patrick Wintour for our fireside chat. Now, we said we'd do this in 3 parts. Patrick will come up with 3 messages. I think I was told, I've not been told which, but I was told there would be three points to kick us off. Then we see what happens after that, whether there's silence ever after. I'll ask a few questions if I can recover from the 3 pointers, and then we open it up for discussions. We should wrap up by 6, and then there'll be a reception just directly outside here. The rain will have stopped, the sun will have come out by then, and we can enjoy our reception. But before that, let's kick it off. Over to you, Patrick.
Thank you very much. Is this working? Is this working? Yeah, okay, so just swap around. Is this now working? Yes, great. Well, look, thank you very, very much for inviting me. It's a real pleasure to be here. And when you said it's a change of pace, I guess that's code from going from academic excellence to amateurish mediocrity, which is what you're about to receive for the next hour. Because I should stress, I am not, I didn't study law at university. And anyway, I was at university so many years ago, I wouldn't remember anything I did study at university. And I'm not also a legal law correspondent. I am a diplomatic correspondent. But it has struck me in the kind of like last 3-4 years, and I've been doing this particular job before being a political editor, which is more like domestic politics. It's really struck me the degree to which law completely intervenes and is at the center of an awful lot of what I'm writing about. And to just give you like an example, I mean, I've had a slightly kind of wild last 2 weeks because I was in Tehran, and in Tehran I was studying and looking at a building that had been destroyed, which contained a nuclear scientist. And at one level, that building was a war crime. You know, obviously you can argue about whether that's truth or not, but anyway, that's how the Iranians view it. And then for some other strange reason, I had to go and interview the Spanish Prime Minister. And one of the themes the Spanish Prime Minister wanted to talk about most was double standards in law and how he felt, because the Spanish are very strong on Palestine, and he was very keen to put over the point that there seemed to be one law for Ukraine in the way the West had approached this issue, and another law for Palestine. And then I went to something called the Gaza Tribunal, which is an event being put on by Jeremy Corbyn. But it was interesting for the fact that the number of lawyers that were there, and on the left, there is now this completely baked in view that a genocide is occurring in Gaza. And it's a point of absolute dispute internally, domestically within the Labour Party about whether the Labour government's done enough or it's done why it won't assert this is a genocide, which is to do with the way in which the UK government and its lawyers determine whether a genocide's occurred, which is that it should be a matter for the international courts alone. And then finally, on the way up here, I was just writing a piece about the fact that the Palestinian Authority are not going to be allowed to send their representatives to the UN General Assembly. And one of the reasons being given by the State Department is that the Palestinians have gone to the ICJ and the ICC, and this is a form of lawfare, and it's prevented there being a peace settlement between Hamas and Israel. So it just sort of, I wanted to say how much it permeates my work the whole time. And then the point adjacent to it, this is the 1.2 point. It's not it's really that the degree to which obviously America is now changing the way in which the law is being viewed. I think it's obviously naive to say that America didn't have a pretty kind of jaundiced view of the ICJ and the ICC long ago. But I just was looking at this exchange between J.D. Vance and somebody else on X/Twitter, in which he started out, J.D. Vance, by saying, killing, this is about Venezuela and the drug runners who were basically destroyed by the and killed. And he said, killing cartel members in Venezuela who poison our fellow citizens is the highest and best use of our military. And a character called Brian Krashstein, who I don't hold any candle for, replied, killing the citizens of another nation who are civilians without any due process is called a war crime. And J.D. Vance replied, I don't give a shit what you call it. And that now is the attitude of America, in the sense that previously there was a sort of disguise about the degree to which they had contempt for international law, and now they're quite brazen about it and publicize it. So that does present a challenge. So my second point was just really about the ICJ itself, and just from conversations I've had, I think they're acutely aware that they don't have very good relations with the media. They tend to put out these very long judgments with no kind of attached press release saying these are the sort of 6-7 points that matter from this sort of 40-page judgment. And I think they know that they need to defend themselves more in the public realm. And they're not doing that at the moment. For instance, there was a speech done by the president of the ICJ just recently about celebrating, was it 80 years of the UN Charter? And it wasn't very long, but you read it. There was no challenge to the UN Charter at any point being conducted anywhere in the world. And it was just, I think the court is beginning to be aware that it needs to, that it is the apex of the UN and diplomacy and enforcement, and it has to protect its credibility. And then the last point I wanted to make was just about the UK government, which is that I think there's a genuine attempt by the Attorney General, Richard Hermer, to put respect for international law at the centre of government thinking. But there's also a genuine attempt to prevent that happening also inside the government. And it's one of the wars going on inside the UK, slightly subterranean, but it filters out into what people feel about migration, the boats, the ECHR. And there's a lot of briefing against the Attorney General, and there was an attempt to get him removed in the reshuffle. And this is about, again, respect for international law. And he himself has written one very good lecture on this point, but he made a mess of the lecture because he made a reference to the people who are contesting international law are equivalent to some of the people in Nazi Germany. And the one thing you don't do in UK politics is make references to Nazi Germany. And so the speech went off half-cocked, which is unfortunate. But he is one of the better forces inside the government trying to protect international law. So that's just my 3 points.
Okay, so double standards, respect for international law, brazen disregard for international law, naivety of those at the apex who think that the charter hasn't been challenged? I think we've got room. I think we've got stuff for half an hour. All right. So, but let me start on a almost personal note, and we'll come back. We'll retrace those steps. I think, I promise. But just perhaps to get us off. I mean, if I'm looking at your writing as a diplomatic editor, and this goes back to what was your first point, or your point 1.1. I mean, you seem to be writing a lot more in your diplomatic brief about the role of international courts or international institutions, but in particular international courts, than your colleagues in rival papers or other papers. And I was just curious. You said you didn't do law. You've worked on the Labour Party. What is there anything that fascinates you about international courts? Is it just their naivety, or is it the belief that they project in a project of international rules? What makes you spend, relatively speaking, more time with international courts than your fellow journalists in other papers or at the same paper?
Well, I think it's probably largely I just stumbled into it. I remember actually during the miners' strike, when there was so much dramatic to write about on picket lines, and I did all that because I was a Labour correspondent. I also spent a long time in the High Court on issues of whether the National Union of Mine Workers would have all its assets sequestrated because it was in contempt of court. And it did have a huge effect on the outcome of that strike. So the law intrudes in a way in which maybe not everyone recognises. I think in the particular case of the UK and Gaza, there has been this court case which has really rumbled on for virtually 2 years, which has ended up really being about quite a narrow issue, which is the degree to which F-35 parts can be directly sold to Israel. But what was interesting through that process was you learned a lot about how the UK arms export control criteria worked. Who did it? What were the decisions they made, and on what basis? Because in their defense, they had to reveal a certain amount about how this process worked, which was kept clouded in secrecy. So the courts can be a way of prizing open information which you wouldn't get otherwise. That's the case in the domestic courts. Obviously, in the case of the ICJ, I mean, maybe it's my naivety, maybe it's the world's naivety, but there was I know from colleagues who work in Jerusalem or have been in Gaza, the degree of excitement there was amongst ordinary Palestinians when the ICJ ruling came out about genocide. And obviously, none of them would have looked at the small print about rights and what exactly was said, or indeed what the retired Chief Justice said after the ruling. But I think it was a moment for them where they felt they had got so little support from the world, and then suddenly this court had come up with this ruling. It was a moment for them of huge importance, and then also for for Israel to be accused in any way, even of indirectly, of genocide, was sort of a blow to them of such proportion. So it's a huge news story in itself. And again, the same applies to the much more long-standing ruling about occupation of Palestine and occupation by Israel, because again, that has consequences for what European countries should do in terms of preventing arms exports, because an occupied country there should be no restrictions on humanitarian aid. So it just has a lot of practical impacts. That's why.
And that impact, so I mean, I think just to be clear, so I think if it is naivety, then it's probably shared by most in the room. So that's not, maybe naivety is the wrong way of putting it. But if we take your example just now, so I think Palestinians jubilant, or for once hopeful, at the issuance of a technical provisional measures order, or Gambians holding up, or let's say Rohingya minority members holding up signs, we're in favor of Gambia because a case had been lodged. I mean, it's difficult not to be touched by that. But if you take your Gaza example now, so if you look at the last 1.5 years, do you think that's symbolism only? Because that's the risk, isn't it? That you create expectations, and then it's not that the last 18 months have delivered on the promise that was perhaps read into the provisional measures order.
Well, exactly. I mean, the issue of enforcement in the ICJ seems to be absolutely at the heart of the problem of the ICJ, that it hasn't a method of enforcement, but it does have a kind of moral suasion and value. But that's why it's, I think it's, if that is its ultimate strength and source of authority and credibility, it needs to do a lot more than it has to defend itself. Because I think at present it just gets hit so hard, and it will, given the way in which America is going, in the way in which America views international law, and has not just the ICJ, but also, what's going on at the ICC, there has to be a much more public political campaign. And I know it's risky for the ICJ because they're judges and they're neutral, but they have to defend their authority in a much better way than they have so far.
Okay, I think I'm very keen to hear what you might suggest to them as a way to better defend themselves, but I think I share the starting point that they need to do more and cannot just vacate that aspect of the field. But perhaps just on you said moral suasion, persuasive force, maybe that's the ultimate vestige. Now, the lawyers will tell you there's also legal obligation, whether it can be enforced or whether you can insist on compliance or make compliance compelling or not. But if we assume that there is a relevance to these rulings, which is felt at least among some, the J.D. Vances less than the Richard Hermers. Can you, because this is something where I think as academic lawyers, we struggle to explain this. So what is it if you take the British government, why do they care if they feel that there is no, what is always now said in the press, the ICJ has no way to enforce its rulings. What is it that accounts for that persuasive force, and how is it felt in a political machinery that journalists like yourself observe a lot more closely than, let's say, academic international lawyers like most of us here?
Well, I have actually spoken to Hermer about this. Why do you care? Because they got into, for instance, a huge amount of trouble about this American base, which they've leased back, Diego Garcia, and they did it because they had lost at the ICJ. I think it was a provisional case, and I can't remember all the details of it now. But he said, if we don't respect ICJ rulings, how can we ask others to do so? So we have to set an example. And he would also say that the period where Boris Johnson was slightly playing with international law during the Brexit period was incredibly damaging for the UK's standing. And that when we sign trade deals, which they've now signed quite a lot, they feel there's a kind of force to those because there's an understanding that Britain overall on these treaties will respect the outcome. That's his argument. They pay a very high price politically for doing so. They've been pursued on the Diego Garcia point absolutely remorselessly by the right-wing press, and there's been arguments about the cost of it all, the need to do so. No one else takes any notice of these international courts. Why on earth is the UK doing so? But to the extent one can find a kind of moral core to Keir Starmer, which I'm not sure it's easy to find. One of them is his background as a barrister, and that there was this period where there was Lammy as a barrister, Hermer and Keir Starmer, and they really made an effort to talk about it and to talk to NGOs about it and how seriously they took it. And they felt they'd made a lot of progress also on the Palestine issue, that they had respected the law by suspending arms export controls in the way in which the Conservative Party hadn't. So it's ended up not working out for them, because I think they've ended up between two stools, neither satisfying the left nor satisfying those who are very critical of international law. But that's the source of it.
Okay. We have got people, we talked about Chagos, the advisory process, the impact of ICJ rulings this morning. So I look forward to the coda to that discussion in the Q&A in a minute. But before that, maybe just to pick up on the point that you've now, I think you made it twice, and I think I fully agree that these institutions are out there, are facing a hostile environment. It's the ICC that is sanctioned, or members of the ICC that are sanctioned. The ICJ, you've said twice, needs to do a better job, or needs to be more, I say, media savvy. What do you think I mean, concretely, if you were hired by the ICJ president who's listening to our fireside chat and heard what you said and maybe understood what you said and felt what you said, what would you tell them to do?
Well, I mean, I have actually spoken to them a bit about it. I just think they need to be much more proactive. Like some of these things are very simple media messages, which any organization does, which is like you pre-brief that there's going to be a very important ruling, that these are the issues. You prepare the when the judgment comes out, you make sure that you've got your 10 bullet points ready, or 3 bullet points, whatever number it is, and you then go out and defend it, if necessary, on television afterwards, which what they tend to walk into court wearing their wigs, walk out of court having read it all out, and that's the end of it, so far as they're concerned. And then a huge debate starts around them, and they're never involved in it. I know some of it's difficult because this is what they said to me, that these judgments are often works of crafty compromise that took weeks of negotiations. And then if you go out into a TV studio afterwards, one slip of the tongue or one sort of bias in one direction or another can upset the whole fragile compromise that you've constructed. And I've seen it with sort of inquiries like the Chilcot inquiry, where that took years and years and years, and then inexplicably John Chilcot then gave a press conference and said things which weren't in the report that then led to all the headlines surrounding the report. So you have to be really careful about it. But these people, I think, just have to be, they have to. Trump is flooding the zone in a way that is absolutely extraordinary. I mean, he's having virtually 4 press conferences a day, and at one point or another, each week, some member of the Trump administration will lambast international law, and at no point does the custodians of international law defend themselves. And like the Foreign Office, for instance, this is in the ICC case about whether they should charge Netanyahu, etc. If you remember, they sought legal advice from a panel of mainly UK judges, and now all those UK judges or human rights barristers, to correct myself, have all had to make sure that their assets can't be sequestrated. For instance, someone might have a house in Long Island and they've had to sort of sell it to their sister, and just to allow that to happen and not to contest this. This person was giving their best legal advice to an international court about whether a war crime had been committed or not. And for the American government then to think it's permissible for them to actually seize their home in America, I just think is outrageous. But you never hear anyone, either in the UK Foreign Office or at the ICC, saying that.
Okay, now if we stick with the ICC, I mean,
I'm sorry that I know we're here.
I think for the ICC, I think it's probably a more acute problem because it goes to really sort of the functioning of the court and the machinery in a way that perhaps the ICJ so far hasn't been hit.
Yeah.
But for the ICJ, nonetheless, one step back, as it were. So I hear what you say. I think I agree with what you say for some of the ICJ's cases. But if we're looking at, are we going by the exception, the South Africa-Israel litigation, or the Nicaragua-Germany litigation, or the big cases? The bulk of the ICJ cases probably won't even get, with even the sensationalism, is probably just to let's say, it's not really sort of newsline stuff. If an island is considered to be Equatorial Guinea's sovereignty and not Gabon's sovereignty, if cases are heard about, let's say, treatment of diplomatic immunities or consular immunities, and it seems to me, I don't want to defend the ICJ here, but it seems to me that one response might be, look, there's a novel challenge, but let's keep this realistic. That affects a small percentage of the cases that are now brought before the court. And for the bulk of the work, it's it's probably too much routine business and functions very well. So the idea of hiring media professionals, of going all out, would probably change the sort of the nature of the court or the nature of the role, and wouldn't really cater towards what perhaps many might see as their real core traditional long-term business. What would be your response?
No, I mean, that is, when I've said this in this conversation, which I've been talking about, that is broadly the response, that they can't be too political. And indeed, they were saying, this person in particular was saying that they're concerned that they might now be becoming a kind of vehicle for disputes which are ultimately either military or diplomatic, to sort of just try to play them out on the sort of ICJ stage. And the example they were particularly citing was this one between Sudan and the UAE, which is, I don't think the Sudan really, it was again a sort of genocide case, but I don't think the Sudan really had any kind of well assembled evidence about genocide. And it then turned on the issue about whether there was whether they'd actually signed up to the full length of the Genocide Convention, or whether they had to kind of opt out for some of it. But they were nervous that they were even taking this case. And I didn't quite understand where and when they could just reject a case altogether, because I think they've struck that case out now, but because the quality of the evidence was so poor. But they are worried that they could become too, the point I'm trying to make is that they are worried that they can become too political, or they become a sort of political football. But at the same time, if they don't defend themselves, they're going to be ever more marginalized.
Okay, now I think time flies. I have two more questions before we open it up. So for those of you who've got a burning question, sort of now's the time to think about a concise way of formulating it in a 20-second to the point way. You can do this after my two more meandering questions. Now my penultimate one. So it's slightly switching the perspective. So assuming that we want the ICJ to withstand or to flourish and possibly even a hostile environment, and assuming that it requires a bit more on behalf of the ICJ to accept that role and accept that it's an away game, if I'm putting it somewhat simplistically, or partly also. Most of us here in the audience are academics at universities pursuing PhDs, postdocs, teaching, etc., international law. I think you would share the hope that the institution survives and flourishes. Do you have any advice for us? Because so far your advice was, what should the court do? But is there any expectation, or is there anything that academics in international law, famously inward-looking, legalese, Latin words, could do to help in that quest?
I was going to say use less Latin, but you've got there before me. I don't know. I mean, this is a more general point about the way universities relate to journalism, and some universities are way more proactive, and some professors are way more proactive than others. And certainly when I was studying politics, it was ridiculous. There was about 3 people you knew you could go to, would give you a very good, concise quote that was usable. And I think sometimes you get these slightly clunky communications departments from universities that send out rather generalized press releases saying, you know, Professor J. Buckhart would be available to comment on the ICJ case, but you have no idea, you know, where they're coming from or what they would say. And sometimes it's just on these really big cases, you know, you should be just sending over material, because you cannot understand the speed with which journalism has to operate. And we get like half an hour, 45 minutes to write the first take. And if there is quotes coming in on email saying what this case means, or the interpreting it in an interesting way, that's worth doing. And I think there's too many academics too bashful about coming forward and just saying their piece. The second thing I'd say is that, well, I can think of 2 or 3 academics, lawyers who are always on, just got my WhatsApp number and are telling me this case is coming up. It's going to be interesting at the ICJ because of X or Y, and they're probably appearing in the case and they're hoping you might publicize them. But I don't think there's any harm just trying to get hold of journalists and to talk to them, send them messages, leave them messages, and don't just rely on writing in academic journals. I mean, I'm sort of weird enough to have started to read quite a lot of that I'm not going to get this name right, but it's the European Law blog, EJ Talk or something like that. Yeah, and I've, it's all written in a pretty digestible, easy way, and I think more of that and less pieces that come out sort of 3 years after the event.
More Marco Milanovic. Okay, this is not my second question. Okay, so all right. So just as a quick response, so I think I spoke to one of those academics who are probably quite media oriented, and that person also said that, look, I mean, perhaps this was self-indulgent, but the idea was that, look, I mean, you might like this or not in normal times, but in times of contestation, these institutions won't survive if we speak to us, said the academic. So we need to make an effort, and I think that probably resonates with what you were saying. My second and final question before we open up. I mean, this is an 80th anniversary, not quite. Next year, the ICJ will celebrate the 80th anniversary. Let's see whether the UN Secretary General will say something about this being the best court ever and never challenged, and you won't be happy with it. But let's fast forward 20 years. What's your crystal ball gazing exercise? 20 years from now, are we going to be seeing a consolidated court that has responded to your challenges, a wrecked court that is marginalized and destroyed by the contestation because the fire was just too hot? Or is it going to be back to normal and the court will settle standard cases and the issues that animate much of your concern will have gone away slightly?
Well, fortunately, probably in 20 years' time, YouTube won't exist. Something will have replaced it. So whatever I'm saying now won't be recorded for posterity. But I'm afraid I'd go down the gloomy route, which is that I just think that if you look at the way the international order is breaking up into blocks, I see that being extended not just to sort of in terms of trade and regulation and war, but I see that being extended to the law as well. And unless people move quickly to defend it, I can see the UN itself sort of breaking up. And I think the very fact that it's stationed in New York isn't going to help it. And if you look at the degree to which it's been so dependent on American funding, and that funding is just simply drying up, and the degree to which Security Council is a non-functioning institution, and why on earth is it going to become a better institution, a more consensual institution in the near future without a pretty decisive war in one direction or another? I just see this breaking up rather than coming back together. Sorry, that's my gloomy view.
Of gloom always, I mean, I don't know, what's the rule? You're either right or you're positively surprised with those types of predictions. Okay, now on that wise note, let's throw it open for questions. We have just over 20 minutes. I'm not sure how many microphones we have. If and when you ask questions, which you all should, be more concise than I was, maybe briefly introduce yourselves and don't hesitate to ask short and specific questions as opposed to what's the state of the world. We start on the far left with Michael.
Thank you, Mike Becker from Trinity College Dublin. Thank you for being here with us. So I'm someone who speaks to journalists quite frequently, and I think one of the biggest challenges as an academic being asked to provide expertise and comment is that the questions I get often demand a straightforward answer, but the questions actually require a lot of nuance to answer. So when I'm asked about, well, what does this aspect of an ICJ decision mean? I would provide a very nuanced answer, but I know that the person I'm speaking to wants something that's much more straightforward. So one question is, what can academics do to be useful to you and somehow find this balance between straightforwardness and nuance? Because I also sometimes feel like once I've given some material to a journalist, I'm never sure exactly what slice of that is going to end up in the piece, and it may not be exactly the part I would have liked. Second question, should more international lawyers become journalists?
Well, I think, but just on your second question, we're probably going to be two sort of Luddite professions, international lawyers and journalists, since the way in which technology is working for journalism isn't great either. In terms of your nuance point, that is just the nature of the game. We need clarity. We need something that is decisive. We don't need something that says, I mean, personally, if I read a comment piece and a paragraph begins "on the other hand," I love it because I feel there's so much didactic nonsense I can read anywhere. I much prefer to rebalance pieces, but in terms of news, when you're trying to comment on an ICJ ruling, you do need something that is relatively clear in one direction or another, and that's just the nature of it. I can imagine the frustration of the journalists when they talk to you. And you are also absolutely right to say that actually this is quite complicated, and basically we have to navigate a way between us to reach a modus vivendi.
Okay, thank you. We'll do a bit of ping pong. Let's
use Latin then, I'm really sorry.
So from the far left to the far right, but everything is a question of perspective. Jacques.
Thank you very much, Jacques Hartman, University of Dundee. Very interesting. I'm going to follow up on the last three questions because I also am quite active in the debate, and I feel sometimes that that I'm a bit handicapped in this debate because I feel one side is arguing with emotions, and then the scholars tend to come in trying to set the record straight basically with arguments and facts, and you just feel that you're always going to lose that game. And I was wondering if you had any opinions on that. This facts versus emotions.
Well, I suppose the one point I would make is actually that I don't know how much television you do, but television is a probably better medium for academics than the kind of 2-paragraph quote in a piece of journalism. So, obviously the number of programs that are going to be that focus on international law is relatively limited, and I wish there were more. But I do think in television, you can get over a kind of more balanced, nuance, less emotive perspective. And, if you do that, then and just find TV programs, outlets that you think are going to be interested. And I would often actually, TV companies are desperate for people to talk. There is so much TV going on, and I get inundated by sort of BBC Wales or something. Sort of you do one interview with them, and then they won't leave you be until they finally realise that you're not going to do it again. And so once you get a connection with a program or an outlet, they will use you repeatedly. And I think actually radio television is a much better medium for academics.
Okay, this turns into a networking job fair. Actually, Michael, you can stop us from going towards job fairs and networking.
I'm Michael Wood, and I used to be a lawyer in the Foreign Office.
Yes.
Now I act for various governments, particularly at the International Court. I think, firstly, to congratulate The Guardian. I think you say a lot more about international law than other newspapers. When I read it, it's like reading a German newspaper. You actually get some law in it that makes some sense. But I think you're asking for something unreasonable if you expect international lawyers to come out within a few seconds and tell you the essence of something. I know some do, and you probably have contacts with one or two who do, but they're not going to really help. The International Court does, of course, issue press releases, which are considerably shorter than the judgments, but perhaps they could be even shorter. On the other hand, beyond that, do you really think that, this is a question, do you really think that the International Court, which is a real court, although in a highly political field of international affairs, can defend itself? The Supreme Court in this country would never do that. The Supreme Court just takes the hits and has to accept it. If it started trying to explain itself, it would no longer really be a court. And I think the international court has to rely upon others to defend it. It can't defend itself. It has to rely upon courts, on our excellent Attorney General, who you've drawn attention to. In terms of enforcement, it relies upon states and upon the UN. And you're asking too much of the court, I think. In order to understand it better, though, perhaps what you do need is to have in your newspaper, on the staff, as it were, an international lawyer who's not just going to pop up and talk about the Chagos issue, for example, but more generally. And that, of course, would be a change in the way the newspaper runs itself. Thank you.
Well, there's no greater compliment than to be compared to a German newspaper. They're works of wonder. I subscribe to 4 of them. But in terms of, actually, I do think, just to do a bit of back and forth, I do think it's sometimes Lord Chief Justice or whoever does defend themselves or does defend the law, and they do give lectures, etc. So, and the point I was trying to make about the speeches I've read anyway from the International Court of Justice, they just don't seem to be addressing any of the contemporary controversies surrounding the ICJ. They seem to be in a sort of never land of their own. And to a degree, you're right that contestation makes things difficult, and maybe you should be hoping the UN Secretary General would, or because it is essentially a UN court, would be doing a better job at defending the ICJ than we see at present. But I would also say that it's also a job of British politicians to defend international law. I listened or watched Lord Mandelson, who's the British ambassador to Washington, give a speech at the Ditchley Foundation on Saturday, and it was a long paean of praise to Donald Trump and no reference to the defense of international law or what he was, the authoritarian tendencies inside America. And it was saying this is a man who he's shaking up the status quo, and it was badly needed to do so, and he's a risk taker. And I know the job of an ambassador is to go abroad and lie for your country and all that stuff, but he'd come back to England to lie for another country, as it were, because I just think he was giving a totally deceitful account of what is happening in America and also to what is happening to international law. And so when you do have these big pulpits, big occasions such as this lecture, I think the British government, because of its very strange relationship with America, the historic special stuff, is very reluctant to criticize American public. And I think that's a shame.
Okay, thanks. We have 15 minutes left. So think about including PhD students, postdocs, whether you would want to ask questions. The next one is from Elenia.
Hi, thank you so much for this. Ellen with Mike University of Glasgow. I was wondering whether you could reflect on your own role and perhaps even your responsibility when you try to convert complex questions or cases or findings of courts to language that the general public understands. And to give you an example, with the F-35 carve-out case, for example, some of the commentary that was out there when the judgment was issued had to do with how the carve-out was legal, said the court. But of course, the court didn't exactly say that. They said more, it's not for the court to review national security decisions, it's for parliament and ultimately the voting public to check the government on what they do in such cases. And so I was wondering whether sometimes trying to turn international law issues that have a lot of nuance or can be understood in different ways in things that general public can understand easily and quickly. There's something there about the responsibility and the role of the journalist as not as the international lawyer that tries to give the straightforward answer, I guess.
No, well, I think I probably cheerfully do violence to the facts most days. You know, that's slightly the job of journalism. You are trying to simplify. And then once you've done your first phase of simplification, there'll be somebody on a sub-editor who'll probably do even more violence, because you've just some of these issues are very complicated, and you can't really digest them into a simple format. I mean, that case and the judicial review case was particularly complicated because in some ways it wasn't really about the merits. It was about whether they were entitled to take a judicial review. And although it lasted for a really long time, and it's almost 2 years, this case, and 4 or 5 days in court, and I listened to quite a lot of it. Ultimately, the judge was saying that this is a national security matter, and this is for Parliament and politicians to decide, and not for the court. So it was really about the extent to which judicial review could apply. But you're right. But within that, there was also an awful lot of legal argument about Genocide Convention, about arms control, exports, legislation. But in the end, when the judge came to his view, it was not really on many of the points that have been discussed during the hearing. And there will now be an attempt at an appeal on that basis, that the judge didn't really look at the substantive case that had been put forward. I also just find it so frustrating that this takes 2 years for to reach court. I mean, it just, you know, justice delayed and etc.
Okay, so we have a bit more time to think about questions. If so, signal. I think I try to fill the second long void. Okay, Neha, please, you go next.
I can hear you.
You can, okay, I'm happy to speak up. So it's a very simple question, actually.
Yep.
Where do you, as someone who really reports on politics, international and domestic, in the context of the United Kingdom, where is the political constituency for defending international law? I think that's the question that has to be answered. I suppose my short footnote to that would say, I think that the ICJ could have the best PR team in the world, and I don't think it's going to make that much difference. There's some basic sense in which international law is losing the political argument in many countries around the world right now. Where do we go with that?
Well, I mean, you're right. I mean, I'm talking about what defensive action can be done, but the context in which international law is operating is incredibly fraught, and we're living in a very nationalistic, populist environment in which national sovereignty rather than international law dominates. But what was, I thought, I mean, not to go on too much about Richard Hermer, but the attacks that were mounted on him on a sort of personal basis, as well as on you know, the politics of international law, I thought was really striking, and it was because somehow the British right do fear and detest international law, and he represented it, and somehow I think I mean, I know some, I don't want to say which papers they're from, but it's not always the case that right-wing newspapers employ right-wing journalists. You all end up on newspapers that you can get a job on. But I know, say, for example, a pretty well centrist kind of guy, I think perfectly sensible, working for the Telegraph, knows that his job is to produce stories that damage Richard Hermer, and that they know their job is to attack international law, and they say that their readership's confused because they thought with Brexit we'd got rid of all this international law stuff and we were taking back control, and now there's this thing called the ECHR, and they don't understand the difference between the ECHR and anything else, and what's the ICJ, what's the ICC, what's the ECJ. It's just way beyond people's daily lives, but it all ultimately comes down to this issue of national sovereignty, and you know, that's a big discussion. Particularly the UK is obsessed by this, but there And then there are people in Downing Street who are very focused, laser-like on the threat posed by reform. And they think, and this is what the argument's about, the way to deal with reform is to fight on their agenda. Other people say, actually, the issue of migration is really about something else. It's about living standards, equality, or education, and we should be talking about those issues. But the more we come up with sort of micro proposals to deal with stopping the boats, the more we just feed the beast, which is reform. And so that's the argument that goes on inside government. And I think, the Attorney General will be on one side of that argument, but he is constantly being attacked as the person who's stopping them taking the measures they need to take to stop the boats.
I have a footnote to Nehal's footnote. So we're all in defense of a noble cause here. International law must be defended, and we're in and sort of the mood or the vibe, dare I say, is that it's under threat, and that's all maybe so. But are we being myopic? I mean, the debate is about perhaps the US brazenly dismissing international law. That was from your first comments. It's perhaps about the right-wing press in the UK. But aren't there also, I mean, either signs of hope or just things that we should also not lose sight of? So to every, I don't know, to every UK that puts an argument for the non-scrutiny of F-35 parts that are real, there's a claimant who challenges that. To every Germany that sees itself on the defense in the ICJ, there's a Nicaragua that steps up in defense. To every Israel that perhaps mounts a sort of a counter attack on institutions perceived as biased, there's a South Africa that seeks to mobilize international justice in support of a particular action. So if our mood is threat, gloom, who knows what the next 20 years will bring, are we ignoring the certainly more numerous but perhaps equally relevant signs for uptake, engagement with, and projections of hope on international law?
You make a very persuasive case. It's true that the number of cases being taken at ICJ are probably higher than at any other point. And maybe that is a sign of respect for the institution, and the fact that so many countries do want to join cases and do want to make their case, is excellent. But I just feel this is an institution that is, given the weight of what we have, what's coming out of America, and the likelihood that that's not going to change, even after another election. This is an institution that people will increasingly question the value of its judgments, since they're not respected and they're not enforced. And we're having more and more rogue states that will take less and less interest in what it has to say. And that's just my kind of over gloomy view of what's going on at present.
Okay, thank you. So reasoned skepticism despite the challenge. Mohammed, what is it?
Online people want to ask online.
Okay, Federica, can we have a quick run through? So, I mean, apparently there's online questions. I'm not seeing them. Can you do this for us?
Yeah, sure.
Pick your favorite one.
Yeah. Okay, there's a question from Rebecca Shoot. I think she's unmuted now. Hi, Rebecca. Can you speak, please?
Yes, thank you so much for full convocation and also for taking my question. I'm coming to you from the United States. I'm the co-convener of the Washington Working Group for the International Criminal Court, and also the co-lead of a campaign for the universality and effectiveness of the ICJ called Legal Alternatives to War. And so I have some responses that I hope will also be questions and not just taking the floor. But first, I think it is fundamentally, unfortunately, naive to think that the ICJ, with its jurisdiction, including banal civil cases as we might look at them, is beyond the reach of the malactors like the United States. I wouldn't be surprised, for instance, if Venezuela seeks to take the United States to court for the recent bombing of one of its ships. And where the ICC sanctions have so far been individual and picking off 4 judges and now the prosecutor and the 2 deputy prosecutors, and as of last week, 3 of my colleagues in civil society, because the ICJ sits en banc, it would probably be all of the ICJ judges that would be subject to sanctions. And it's not just if you have a house in Long Island that this affects you. If you do any banking with, it doesn't even need to be a US bank. Most European banks also work with the American financial systems. And so this is something that at the ICC, we've been preparing for a while with registry, but still is very much outside of the manageability with the limited resources of that court. And with the ICJ having even fewer resources and also being subject to the UN 80 initiative, which is going to curtail perhaps its budget even further and its human resources even further, I think this is something to be very actively concerned about. And it's, of course, not just the United States brazenly dismissing, I think was the terminology that was used, the court's decisions, which is, of course, nothing new. I mean, we have Nicaragua from 1986, Nicaragua v. United States. But it's also non-cooperation of other states. So the Legal Alternatives to War campaign, where we're trying to get more than 74 states to accept a compulsory jurisdiction of the court over contentious disputes, it's really hard to make that case right now. And it's having a chilling effect. The climate is having a chilling effect on those of us who advocate for the universality or the effectiveness or the ratification of treaties in general, and the acceptance of jurisdiction of the ICJ over contentious disputes in particular. And here I couldn't align myself more strongly with the comments made by Sir Michael Wood that it is not the responsibility of the court to reach and to be its own defense. And in fact, in some ways, I think that's quite counterproductive, especially from a US standpoint. And I say this, I served in the presidency of the ICC and wrote the speeches for the president, arguing for universality and standing up against the deniers. The ICJ, A, does not have that capacity, and B, neither court, for that matter, really should be in a defensive posture. But in addition to the role played by academics, here civil society really needs to come in, must come in and advocate to member state governments and anyone who will listen, of course, including the media, on the importance of the international courts and tribunals. And here we do point to the implementation of ICJ decisions in the long run, in whole or part, even Nicaragua v. United States for that matter, while the United States very much adamantly disagreed with the outcome of that case, it moved the needle in terms of the ultimate regional politics and funding of Contras, not only in Nicaragua, but throughout Latin America, and paved the way for a peace process. And so therefore, I offer to all the academics in the room, of course, to the media and to legal professionals to consider the different platforms that you may have and really ask your governments to step up. And for the media, I think we don't want to sugarcoat when we talk about the implementation, for instance, but we do need to talk about the importance of these courts and tribunals and not just defer to them to speak for themselves. Sorry, thank you so much for the time and for making this opportunity possible.
Thank you, Rebecca. Patrick, any responses to that comment/questions, or?
I didn't actually hear the question at the end, but I thought most of what she said was, she's obviously hugely well informed, and I'm not going to challenge any of that, except I do think, and then I've argued this already with someone Wood, about whether there is a case for the ICJ to be more active in its own defence, and I just think an institution like that is beholden to it to be more active than it is at present. But that's my main point, which obviously others disagree with, because the legal profession should remain more neutral and above the political fray.
Okay, now that brings us to the end of this fireside chat. Not sort of the feel-good vibes you might have been hoping for from a crackling fire at the end of a day, but hopefully instructive nonetheless. To the extent that you hope for more good vibes, you can now reclaim them over a glass of, I think, wine or juice or nibbles at the reception, and that's the spirit bouncing back for international lawyers. But before we go to the reception, which is just outside, as I said, let's thank again Patrick for coming here, for speaking to us.